Thank you so much, everyone, for joining us for the SATIV webinar about liability and legal implications of COVID-19 on tourism businesses. COVID has certainly thrown a cat amongst the pigeons when it comes to liability and risk mitigation and management. I think we're discovering little worms everywhere, every single day. And we know that there's no public liability insurance cover for COVID. That doesn't mean there aren't a lot of questions around liability and potential litigation if a guest falls ill, or worse still, if they die from COVID. What is your responsibility as a DMC, as a wheels operator, as a hotel, as a game lodge, etc., etc.? What happens if they have to curtail their trip? Or perhaps you just need to prove that you haven't been negligent as a business owner, and what does that look like? So joining me today to unpack this is Stefan de Beer, Director of Martin de Beer Inc. You guys have seen him on a webinar with me before. He's a fountain of knowledge, and I know that he's going to give us some really good advice today. It's not legal advice, hey Stefan, it's just guidance.
Yeah, this is just it's one of the rare occasions you get free information from an attorney, but unfortunately does not constitute legal advice.
Awesome. Thanks for clarifying that. We have also a familiar face in the industry, Anna Vegters, the MD of Wild Wing Safaris, who was actually the person who highlighted the need to run this kind of webinar. So thank you, Anna, for that. And last, we have Lucien Niemann, who is from Africa Rescue Live Assist. He's the executive director, and he is our genie when it comes to all things health and hygiene safety protocols. So we really look forward to his contribution today. We want to see your contribution too. We'd love to hear from you, and we will be taking questions through today's session. You guys have been on this webinar with me before. You know what the format is. And for those who have forgotten after the festive season break, there is a Q&A folder at the bottom of your screen. Type your question in and it'll come through to me, and I will pose those questions through to our panelists who will endeavor to answer them. I'm also going to leave the chat open, and I can see you can actually chat to panelists and attendees. So please feel free to let us know where you're connecting from. We'd love to see who's in the room, where you're coming from, and if you have any questions, prefer for those to go on the Q&A, but please feel free to use that chat just as a conversational mechanism. Just one last little thing. I know that business interruption insurance is our hot topic at the moment in the media, and there's been plenty of coverage around BI insurance. This webinar is not about BI insurance. So just as a disclaimer, if I do get a BI insurance question, I'm not going to pose it because it's not relevant to the specific discussion. But yeah, feel free to send me an email at meetings@bigambitions.co.za if you do have a BI insurance question. Right. Recording will be released probably in the next couple of days. So give us a day or two to get that out. And I think that's all the housekeeping I have. So enough from me. I'm going to hand over to Anna, who was the guy who raised the flag and said, have you people been thinking about this? And I had been thinking about it, but Anna, as I discussed earlier, would rather have been sitting underneath my bed and eating a Kit Kat than thinking about it. So tell me why you are concerned and why we should be concerned.
Thanks, Natalia. Yes, I'm not here really as an expert on it. I'm here to ask the questions, and hopefully the experts can answer them for us. I can share a little bit later, perhaps, some of the things that we did. But I got thinking about these type of questions when I realized that we no longer have liability cover for COVID. And COVID is our #1 risk right now. The risk of people getting COVID, getting either on a trip with us at a lodge or on a tour, or being having their trip cut short, being denied boarding, facing financial implications because of showing symptoms or testing positive during a trip. Or if you have a very litigious guest who gets COVID and wants to blame it on someone and tries to sue us for damages, claiming that perhaps we haven't, followed all the protocols or done everything that we could to prevent them from catching COVID on the trip. And as I started thinking about this, more and more examples of how this could happen came to me. We had a couple of thankfully, a couple of tours that we ran in December and one now in January, and we've already had to deal with some of these things. We've had a guest who tested positive at the end of their trip and couldn't fly back. I also have a friend in the industry who recently told me about a lawsuit from a $3.5 million lawsuit from a client of theirs who basically just bumped their nose on a game drive vehicle. That's nothing to do with COVID. That was a couple of years ago, but it just shows how, the kind of sums that you could be looking at. That was not a death or anything like that. That was just a couple of stitches in their nose, and they came back with a $3.5 million lawsuit. So there is a lot to be concerned about from our perspective as operators, as tourism establishments, maybe as safari lodge owners or hotel owners. And so let me explain some of the thoughts that I had. One of the questions that came up is, how many symptoms, for example, does a guest need to show to be disqualified? And picture, for example, a guest who has a persistent cough. A cough is a symptom. We ask them if they have symptoms. Of course, many people will possibly lie on their declaration forms because they know that if they say yes to any of those questions, they will be denied boarding. But some symptoms you can't hide. Your temperature is taken. If your temperature is high, we have a decision to make. And maybe it's an easy decision if it's a super high temperature. Maybe it's a harder decision if it's around 38 or 37.5. It's elevated, but it's not a definite fever. And that person definitely does not want to have their trip cut short. They're adamant that they're just a bit hot or they have some other reason for it. And it's definitely not COVID. Someone who has a persistent cough, perhaps they're sitting on the game drive vehicle and they're coughing, and other guests are starting to comment about it. They're getting uncomfortable having a coughing guest on the vehicle with them because everyone's immediately thinking COVID. But that guest doesn't want to be removed from their trip. They've paid for this. They've looked forward to this. And they insist that it's a smoker's cough. It's nothing more. What do you as the operator do? If you remove them, that guest might be so unhappy. They might threaten negative reviews. They might threaten claiming their money back from you or, demanding refunds. So you're going to have problems with the guest who's removed. If you don't remove them, then you run the risk that one of the other guests, if they should test positive or get COVID, that they blame you as the operator, and now they have proof that you were negligent because there was a coughing guest on the vehicle and we did complain about them and you never removed them from the vehicle. So in my mind, this has, there's no falling back on your insurance company. You don't have a team of lawyers behind you that are going to fight these battles for you and sort this all out afterwards. So it's a much bigger risk now that we have to deal with. And as operators, what is the only way that you can ensure that we are safe and that we don't face lawsuits of millions of dollars afterwards, or a series of complaints, unhappy guests, negative reviews by people who had their trips cut short or who were denied boarding. If we all know the protocols as they stand, if a guest on a tour, and I mean, my perspective is that of a tour operator. I'm a tour operator with a fixed group. So if, let's say on day 2, a guest starts showing symptoms and it's a small group tour, let's say there's 8 or 10 people there, and on day 3, we refer them for a test and the test comes back positive. What do you have to do now? Do you have to now cut short the whole tour? Everyone has to go into isolation. That's how I read the regulations. That's what has to happen. You will sit then with 8 or 10 or however many guests you have, very, very unhappy clients who themselves don't have any symptoms, are not positive, but have purely been exposed to somebody who's shared the same vehicle with them. Maybe they came on the same transfer from Johannesburg to the Kruger National Park in the same vehicle. And so that meets the requirement of having been exposed to that positive individual for a long enough period of time to also have to go into isolation. So all of a sudden, your guide, all your other guests, everyone has to cut their trip short and go into isolation. I can guarantee you that you will see a whole bunch of refund requests. Everybody will want their money back, but you as the operator have already paid suppliers. You're going to be facing cancellation fees. I know the cancellation policies have been relaxed, fortunately, in the industry by many, of the suppliers, but most of that is before travel. So if somebody, for example, if a new lockdown appears or new travel bans, or they don't manage to get a positive test, maybe their test is negative before they arrive. But once you're in country, a lot of those relaxations are out the window. Once you're in country, if you cut your trip short, you will forfeit whatever has been paid for the rest of your trip. The rest of the accommodation very likely will not refund you. And so we as the operator will have to, decide what to do with refund requests. So it just opened up a huge bag of possibilities and questions that we have to answer. And for now, my only response to that, or answer for myself to that, is we have to be so careful with our paperwork and with the way we write standard operating procedures. You know, even your guide in that, if you picture your guide in that situation, your guide may or may not phone head office and say, listen, I've got this coughing guest. He doesn't want to leave. He wants to stay. Everybody else wants him to go. What do I do? He's got to make a call, a judgment call. If there are not standard operating procedures in place that can explain exactly what should happen, it's much harder at the, later on to prove that you were following the policies and guidelines and were not negligent. But that brings me back to the regulations that we have. We currently do not have a set of legal requirements, but we have a set of voluntary regulations by the TBCSA that we've all self-subscribed to and self-certified, which are great, but they are very comprehensive. And some of those things may not be practical. There's one, for example, if I remember correctly, there is a clause that requires on longer trips that you have to ozonate or fumigate your vehicle. Now, imagine I mean, I'm thinking of our trips, for example, to the Kruger National Park. We do not have the equipment or the facilities during a trip like that to fumigate or ozonate that vehicle at the end of every day after game drives. So we don't do that. So now are we in, because we are in breach of one of the regulations, in theory, are we open to litigation? Are we open to claims of having been negligent because we didn't follow the protocols to the letter? Those are the kind of questions we need to ask ourselves. So from our side, maybe a bit later on, I'll share a little bit about what we've done, but I'm keen to hear from the experts how can we address these concerns? How can we ensure that we as operators, as safari lodge owners, as tourism establishments, do not create a massive pitfall for ourselves and at the risk of being sued, or maybe not being sued, but just facing a lot of backlash from unhappy customers who have their trip cut short. They want, refunds, or they write poor reviews. It's a minefield out there, and hopefully there's some answers for us.
Yeah, I mean, it's not just about the legal liability. There's a reputation management issue, which has far-reaching impacts on your business, Anna. Thank you for raising those. So, Stefan, you've heard Anna, and my understanding is that he's really trying to invest a lot of time in that first line of defense. We had a little discussion before we hopped onto the call about how we used to have both lines of defense, and the second line of defense is essentially non-existent anymore. Talk to us. Tell us a little bit what's come to mind based on what you've just heard from Anna.
Okay, well, first off, as with most things, especially in the law, there's unfortunately no such thing as a one-size-fits-all. It all comes down to, and all may be a strong word, but it comes down ultimately to the specific set of facts of every matter. I understand Honor's uncertainty and cautiousness when it comes to the TBCSA tourism and hospitality industry standard protocols. The short answer to that is, if you consider yourself certified, as I think they issue a certificate of sorts to confirm that you are compliant with their protocols. If you certify yourself or have yourself certified as such, then you are bound by it. So you must keep in mind that if you hold yourself out to be fully compliant, then you are to be held liable in accordance. My advice and suggestion would be to those who aren't able to fully comply with each and every regulation or protocol in those set of protocols, is to simply make it available to your clients and your customers and advise them, listen, we try as best we can to follow these protocols, but obviously due to the nature of our operation, or the basis on which we normally operate, or the types of financial implications, or whatever we've got to our available to us, this is why we won't be able to follow it to the letter, and advise them. I mean, ultimately, when you have clients, you enter into an agreement. Each and every client enters into a contract with you. The moment you offer your services, they accept it and they pay for it, and you start to render your services, you are bound by a contract. So if both parties understand that it is more of a risk to enter into this contract today than it was 2 years ago, for example, then both parties accept that risk. On your question as to how many symptoms, for example, one must show before you ought to be disqualified, I mean, that comes down ultimately, again, you ask yourself the question: would you rather err on the side of caution, or would you take the risk? Business in itself is risk. For the tourism industry at this stage, obviously due to COVID, it's become hell of a lot riskier than it was in the past. But your appetite for risk is something that you must evaluate. I've always kept the mantra: no business is better than bad business. So if you anticipate this type of risk, you must ask yourself the question: am I willing and able to take on the risk? Is there a way for me to mitigate that risk at this stage? As Natalia said earlier, in the past, we could use our terms and conditions and our contracts and our booking terms, and we could use that as our first line of defense, along with whatever indemnities you've got, and to then afterwards to pass it on to our insurers. At this stage, no longer a possibility. So what was once first line of defense has now become the most crucial, if not the only line of defense we've got. So it is even more important now to fully understand what it is, the type of risks you are going to expose yourself to, and to then provide for it as best you can by way of a contract. Will that prevent people from litigating against you? Unfortunately not. Nothing can prevent anyone from approaching the court. Nothing can, in any event, fully indemnify you against negligence or intent or breach of contract or whatever. The reality, however, is, what is negligence? I think, Natalia, I think you asked that question earlier. What is negligence? How do we know we acted negligent or we didn't? Again, comes back to that reasonable person test that our courts ordinarily apply. The question is, what would a reasonable person in your position, what would they have done? Reasonable person is not an expert in any way, shape, or form. It is someone with similar experience to you, in a similar environment as you, someone with access to similar information as you. And what would they have done? That is ultimately what the courts would look at when they ask the question, have you been negligent? One of the other issues that arises in this instance is, do we have a burden of proof? Must we as tourism industry stakeholders prove in one way or another that we weren't negligent? The rule of thumb is that he who alleges must prove. So if someone alleges that we were negligent, then they must prove that allegation. Will anything stop them from making the allegation? Probably not. What can we do to mitigate the possible impact of such an allegation, or how do we go about proving them wrong? Anna said earlier, look at your paperwork. Apart from your terms and conditions and your indemnities and so on, what I have advised a client, I think in the past week, ensure that you've got your clear operating procedures. You understand your business better than anyone else. You know the type of suppliers you use. You know the type of guests you entertain. You know the types of tours you undertake. Because you are in the best position to understand your business best, you are in the best position to advise either your attorney or legal advisor to come up with protocols to fit that. It would best be for all of us to sit down, take ourselves through our own business and understand what it is we do, look at all the possible risks that we see, and then to take it to someone like an attorney, for example, for them to have a look at it, to assist you in that way. That will, one, save on costs from a legal perspective on your side, and secondly, it will also make you more clued up into your own risks, because sometimes, if not most of the time, it's easy to pan off risk and the difficult questions and the tough decisions to some form of either legal advisor or insurer or whatever. Now you can understand and see in minute detail what's happening in your business, where your risks are, and then you can without incurring a lot of costs, you can essentially manage it a lot more efficiently than we have in the past. What I suggest one does is you draw up your operating procedures for your business. You make sure that you understand your business and your operating procedures. Then once you draft them and you consider them yourself bound by them, ensure that you enforce and apply them vigorously. And it's not only you as the owner, but it's your staff. It is your contractors, your suppliers. You must ensure that each and every one is on the same page when it comes to enforcement of your standard operating procedures or your protocols. Advice would further be document your cleaning activities, document your preventative measures that you've taken every single day. Ensure that you, as far and as best as possible, in as narrow detail as you possibly can, jot down everything. Paperwork is flippin' important. Remember, the courts do not want us to be perfect. The mere fact that someone, for example, contracted COVID does not necessarily mean there's a claim for damages. It comes down to the question of intent or negligence in the case of a delict or in breach of contract. Did you act in a way that could or did in fact cause the harm? And if so, was that harm caused either intentionally or negligently? So the mere fact that there's harm of sorts is not sufficient to be held liable. On the question of negative reviews and people demanding refunds, that's unfortunately the PR issue we face day in, day out. It is more so nowadays. But that's again the question you have to ask yourself as a business owner. What am I going to do about these possible negative reviews? If I tell clients that you won't be receiving any form of refunds due to curtailment, the client can either say, sure, can't we make a plan of some sorts? Can't we postpone? Can't we get a discount in future? How about a voucher of sorts? It comes down to a business decision more so than a legal decision. If your paperwork is in order, you either enforce your paperwork as it stands, or you try to mitigate your PR losses or damages. And on the question of, okay, so now we cut short the trip, we go into isolation. Or should we go into isolation? Yes, we should. I suspect Lucian will best be in a position to advise us on exactly what those types of things may entail. But from my perspective, yes, you go into isolation. It's your duty, not only as a business operator or business owner, but it's your duty as a citizen in general to, as far as possible, to prevent the spread of this exceptionally bad disease and virus. Just to give you an example again, the question is, okay, but what if we weren't close in such close contact? I mean, I read an article two days ago, I think, about the Australian Open tennis players. There were 3 people who tested positive on planes that flew them into Australia, and I think 47 players are now in self-isolation. So strictly so they can't leave their hotel rooms. And that's the type of measures one will have to undertake to ensure that you stop the spread, because this thing is getting worse day by day. And apart from our business risks and our business issues and concerns, one must understand that this affects everyone, and all of us are at risk. It's no longer the case of say, yeah, but it's not going to happen to me. I won't get that sick. We've got so many people dying on a daily basis close to us as a result of it. So understand you've got business risks, we've got business and legal issues, but also remember we're talking about people, and we affect and influence people's lives on a daily basis.
Stefan, why is it that when you and I are on a webinar together, I leave the webinar feeling like I have to, I don't know, put myself in a padded cell and hide away from the world?
No, you don't have to do that. You just have to put us on it, and we'll sort it out.
Okay, perfect. Lucian, I know you're grabbing a little slick of coffee there, but if I could ask you to unmute yourself. We spoke a little bit about the protocols, and Gillian, I'm so glad you're on the webinar. Thank you for throwing the comments into the chat. And yes, we do need to review those guidelines because they came into force before we actually had an opportunity to actually practice them. But we had an interesting question from Martinez, and he said, are the protocols law or are they guidelines? And I know that they're not regulated protocols, that they are guidelines. But Lucian, you're dealing with these protocols on a day-to-day basis. How do you navigate the minefield of what actually is feasible, what is unfeasible, so that you feel intrinsically that you are doing right by your customers, essentially?
Look, it's a very complicated subject because, as we all know, there's the TBSA, there's the Department of Health, there's the NICD, there's the World Health Organization, blah blah blah, and at the same time, there's a lot of the tourism industry. At the end of the day, we deal with international guests and we deal with people that come from overseas. So there is an element of international standardization that is also required. So it does become very complicated, and one doesn't expect the likes of owner or any other tour operator or lodge to be experts in the subject. At the end of the day, that is why we have professionals such as Stefan, who's a brilliant attorney, and then you've got the likes of doctors and occupational healthcare experts that are there in order to give the recommendations in terms of what needs to be done from a safety point of view. At the end of the day, COVID-19 is a medical crisis. It's not a fire crisis. It's not about HIV or anything like that. It's specifically about infection control, prevention, and obviously cleaning protocols and all of that. So at the end of the day, what you need is a medical perspective. And so that's why, for example, under the TBSA, they specifically refer to the fact that the protocols have been reviewed by an epidemiologist, because that is exactly the type of individual we need advice and guidance from now. So what we've done from our side, obviously, yes, there's Africa Rescue, which is a case management assistance company, but I'm also heavily involved with another company called Africa Safety, where we do medical advice for lodges in the safari and tourism industry. So the point is that what we have done for Africa Safety and for our clients there is we've put together a set of protocols where we took the TBSA guidelines, we took the World Health Organization guidelines, the CDC guidelines, and the NICD guidelines, and we basically put together what we view as the protocols that should be implemented. Now, you'll notice I keep referring to protocols and not regulations. The fact is, the only regulations that anybody has to follow is the Department of Health regulations and the Disaster Act regulations. That is law. The TBSA is a pledge. It is a guideline. It is a safety mechanism for tour operators, overseas that are booking clients to be able to say, hey, this is a set of protocols. These are industry leaders. They are the council, that pull all these companies together. And they have looked at what they believe is standard operating procedures. And this particular tour operator who we'd like to book you with has pledged to uphold that standard. Now, the important thing is that if you read through the TBSA guidelines, it specifically says where possible, where you can do that. The guideline is, it's an intent. The point is the document is about intent. It's sitting there and it's saying, this is what we believe you need to follow. You as an business operator are agreeing to try your best to uphold that standard operating procedure. The pledge specifically relates to training. So it says training, it says PPE, it talks about those things. The fact that there is a COVID-19 compliance officer, that there is a quarantine or isolation facility that has been planned for. I mean, for example, in the lodges, we haven't advised them to go ahead and dedicate a room, because the point is that a guest is staying in a room. So we, for example, have recommended that they create a mobile isolation facility where they have a kit that they can put together that has got masks and PPE and gloves and pulse oximeter and all of those things in, so that when a guest has got symptoms or whatever it might be, you isolate them to their guest suite, which is where they are already. You're containing them inside there, and that becomes your isolation. What the TBSA is trying to say is, guys, have a plan. Have a plan in place on how you're going to isolate people. Put training into place. Just the point is, have the good faith to be able to do the best that you can. And then when it comes to regulations, you must follow the Department of Health. So in terms of isolation, Ona was speaking about a symptomatic group of people and they're all in the same vehicle together. Yes, absolutely. They're all going to have to isolate. That's not a recommendation. It's not oh, if I want to. It's law. They have to isolate. That's the regulation. If you have come into close contact with an individual that is symptomatic, or so more specifically, actually, that is positive, you need to go into isolation. So the point is that, yes, until such time as that positive test result comes back, they can go wherever they want to, because the point is you have no confirmation. But once there is that positive test result, they all have to go into isolation if they have been deemed to have been a close contact. And there are very specific requirements to determine a close contact. If I'm sitting there and standing there with someone and I'm talking to them and I've got my mask on and I'm within the social distancing barrier and I've got a face shield on, then I'm not deemed a close contact because the protective mechanisms and the personal protective equipment is in place. But if I didn't have my physical barrier, so the face mask, and I didn't have the face shield, then I would be deemed a close contact and would need to go. The other side of a close contact is also being within an enclosed space for more than 15 minutes with an individual, so without PPE. So, for example, you've got the people in a transfer vehicle that is sealed and closed, like a combi. That would be deemed close contact because they're in that thing. If they've been in there for more than 15 minutes, it's a close contact. But sitting on the deck of a lodge having dinner, where your other guests are more than 2 meters away from you, that is not a close contact. Not all those people have to go. So at the end of the day, from a tourism point of view, I wouldn't recommend that you take groups of people together unless they are part of the same group. Because the point is taking one couple and taking another couple who are completely unrelated to each other and putting them into a vehicle, you do stand that risk. And as Stefan said, people have to make a decision as to what level of risk they want to take. But at the same time, if the guests are turning around or your passengers and they're saying, we're happy to do that, we know that these are complete strangers and we know that we're going to get into a vehicle together with them and we don't know what's happening. At the end of the day, that is their choice to make that decision. But the point is that not everybody goes into isolation. There is a difference between regulations and guidelines. And at the end of the day, you need a medical partner that can advise you based on your operations. The TBSA is about intent. It's about following the guidelines to the best standard that you can. Some of the things they say is an absolute, but the majority is where possible. The guidelines are, it's not an absolute definitive. It's a case of adopting them and adapting them to your business.
Thank you, Lucian. And I have pasted in the chat links to both the Tourism Business Council, TravelSafe, EatSafe.coza website that also has information about the app, and within the chat as well, the fantastic Africa Safety COVID-19 guidelines that Lucian was talking about a little bit earlier. If you have a question for any of our panelists, please feel free to throw that into the Q&A. We've got loads of questions. So with your permission, panelists, can I just dive right in and start asking them? Or Ona, did you want to say anything in response to Stefan and Lucian's
I'll just make a brief comment that, what I heard from Stefan is that it's something that raises a bit of a red flag to me, because he's saying, you must decide. It's your business. You must decide your appetite for risk. And for me personally, that doesn't cut it. That's not what I'm looking for. I need more specific guidance than that in terms of what will expose me to possible litigation, because I can't afford litigation. I can't afford, even if I can win it. Long before I win the case, I'm spending thousands on lawyers, and it's going to be many months. And if it happens in a different country, if we sell all of Southern Africa and East Africa, and my case is in Tanzania or in Botswana, for example, then I have to pay lawyers over there. They might drag out the process. They want to get the maximum from this as well, whether or not I win the case. So there are massive risks for me to just make a call based on what I think and what was best for my business. And with this whole thing, you're weighing up what is best for business versus what will limit our liability and our risk of litigation. And to use this example of what Stefan said about the protocols, if you self-certify that you will comply with it, then you've tied yourself to that, and you have to stick to them. If you don't stick to them, you are liable. So what I hear in that is, don't self-certify.
Yeah.
Because you're putting yourself at risk. And so we are taking a very positive set of protocols that will really help us get business and reassure our guests and so on. And yet we have to, we can only say we'll use these as guidelines, but we're not going to self-certify that we are going to comply with that, because that leaves us open to litigation. And what Lucian said about, don't take guests from who are not unrelated and put them on the same vehicle. Well, that's a huge part of the industry. Scheduled tours, small group tours that operate on scheduled departures, overland trips, even game lodges. You hop on a game drive vehicle at a safari lodge, you are going to share that vehicle with other guests and sit next to someone who's not related to you. And of course, we're now trying to keep distance and we wear masks and so on. But I can tell you from personal experience, from having chatted to different lodges and sent guests to different places, they do not all comply to these regulations or to these guidelines. There are safari lodges that, especially now in the hot summer season, it's 40+ degrees out there. They have said to us straight, we do not enforce masks on the game drive vehicles. And I drive around in Kruger and I look around and I see that very few of the other open safari vehicles with guests on them have their guests wearing masks. Now, I personally may feel that that's fine because you're out in the open air. The risk is tiny. It's very well ventilated. I can understand why you don't want to get all hot and sweaty and clammy under that mask. The guests are going to take them off anyway, and you're going to have to keep policing it all the time. It's a mission. But for me as the operator who might face litigation, I have to ask myself, can I send my guests to a lodge where they don't enforce masks? Can I, how strictly do I have to police this on my own game drives in Kruger? Do I have to make them wear masks? Because if they don't, I open myself up to it's very easy for the guest to snap a picture if he starts to get worried, or thinks of the potential of, litigation. Snap a picture of the rest of the guests not wearing their mask, and now he suddenly has proof that we did not comply to the regulations, because look here, your guest didn't wear masks. So that's why I'm saying it's a minefield, and I want more information than just, no, you must decide. You know your appetite for risk, you know your business, do what you think is best for you. So sorry to be devil's advocate, Stefan, but those are the questions that we face in the industry.
Yeah, see, unfortunately, the free information stops about there. It comes
Stefan,
down to...
your mic is a little bit soft. Is there any way you can turn it up or sit a bit closer?
It comes down to the free advice ends there for now. If you want more details or more specifics or particular advice to your situation, again, the advice given or the suggestion made was, understand your business, go through it. If there are certain risks that you aren't willing to take, or you yourself don't want to take, or you want to mitigate, you just don't know how, after you've done that internal exercise, then approach your legal advisor, approach your medical experts, to then, firstly, it'll be quicker to do so then, and it'll be cheaper to then at least, because then they'll get an idea of what your business entails, and they'll best be in a position to advise you on what you can and what you can't. But if you don't undertake that exercise yourself, it's very difficult for an outsider like us as attorneys or medical experts to understand and advise you if you yourself don't really know what it is you expose yourself to on a daily basis. So if your concern is, but you don't want to make the decision as to whether or not you're going to take this risk or not, identify your day in, day out activities, identify the type of operation you run, and then take that to the experts for them to then advise you. Listen, this is the type of risk. This is what may happen as a consequence of taking on that risk. This is how we can mitigate it or stay away from that one. That's as far as I'm concerned, probably the best way to go about it, but that'll cost money.
Okay, guys,
I-
right. We have a, oh, sorry, Lucian. Okay,
Yeah,
I'm
I
going to
was
let
just
you
going to
say
jump in there
quickly.
quickly. I agree with Stefan where he's coming from, and I also understand where owner's coming from. But in terms of the concept of people wearing masks and the concept of lodges, and I've experienced this, a lot of operators not following the regulations. It's important to understand that there are certain things that are absolutely required, regardless of whether people want to follow it or not. It's not even about accepting risk. The Occupational Health and Safety Act was adapted to the COVID-19, and there's an onus on the business to have a COVID-19 compliance officer. It's not a question, it's a requirement. Every business must have one. And that individual is required to make sure that the certain basic regulations are followed, such as wearing a mask in public places. So if a person is not wearing a mask and they are that, you're absolutely correct. If they take a picture and they get COVID, you are going to have a problem with the authorities, because the fact is, from an occupational health and safety perspective, you cannot not follow certain basic regulations, such as wearing a mask and socially distancing in the commercial space. So I just wanted to put that out there.
Great point. Thanks, Lucian. Okay, we have tons of questions. So I'm going to quick fire those questions, and we need to keep it short and sharp because we are running out of time, please. So let's try and get through as many of these questions as possible. I'm going to batch some of them. There are quite a lot of questions that have come in with regards to the distribution channel. So actually, who is going to get sued is the nub of it. Is it going to be the travel agent overseas, the tour operator overseas? Is it going to be the lodge for not complying with the protocols that are in place or with the regulations, the actual the Occupational Health and Safety Act? Who is the entire channel going to get sued, or is it just going to be elements of the channel?
The one with the most money, I would say.
Well, if it's tourism, no one.
Yeah, at this stage, unfortunately. As I suspect, we'll see what we call a shotgun approach. So everyone that they can possibly get their hands on will receive a summons, simply because it'll be a best way to litigate. Is firstly, but again, it comes down to the exact and specifics of each and every case. As I said earlier, nothing can preclude anyone from approaching a court. So the mere fact that someone issues a summons against you does not mean that you are liable. But I anticipate and suspect, as I would do, luckily I'm on the other side of the fight. If I were on the wrong side of the fight, I would simply line them up and start shooting. So unfortunately, the reality is everyone is in the crossfire. Yeah. So make sure
Even the
that you're.
Even the tourist guide, everyone.
Yeah, they'll line up everyone. I would.
You're a hard taskmaster.
Yeah.
So Chris has asked the question about the geography. So let's say the client came through an overseas tour operator or travel agent. Where would that case be heard? If it was a German tourist, would the case be heard in Germany, or would it be heard here in South Africa?
No, it comes down to, again, normally our terms and conditions and our booking forms and so on would fix a jurisdiction, likely South Africa if you're a South African operator. If you're elsewhere, the jurisdiction can also be found where the services are rendered. So the mere fact that he's a German traveler, he can't sue you from Germany. Number of reasons. One being those courts won't be able to enforce a decision against a South African operator or an African operator. It won't make sense. But you do run the risk if you've got a German traveler who undertakes a tour to Tanzania, for example, something happens there, then they are allowed to issue summons and lay claim in Tanzania. What, however, in practice would in all likelihood be the case is they would likely follow you because they'll go after you for your assets. If you don't have assets in Tanzania, for example, then it serves them no purpose to issue summons there. In South Africa, jurisdiction is found on one of the grounds is where is the defendant, and if the defendant is located in South Africa, then jurisdiction ordinarily and as a matter of fact follows you, so you can be sued here in all likelihood.
Stefan, lots of questions around T's and C's. The devil is in the detail, I know. So, you know, the customer signed the T's and C's, you've put in a waiver, some sort of COVID disclaimer or non-liability disclaimer. Tourists know the risks, they understand their responsibilities, they've signed those T's and C's. How will the indemnities, are you covered? I mean, is that like the blanket Hail Mary that we're kind of all looking for, or not really?
Yeah, as I said earlier, what once was the first line of defense is now the main, if not only, line of defense. Yeah, it's not the only line of defense. I think we should remain to see our terms and conditions and our waivers as our first line of defense, and then the enforcement thereof will be our main defense. So if your terms and conditions, which is my advice would be, is to include reference to your protocols with regards to the COVID regulations and stuff that you implement, so that you can ultimately say, listen, you've got all the information, you understood that there's a bigger risk. We also understand that not only are we taking a bigger risk, but we've taken on a bigger responsibility, because we have now bound ourselves, whether it be directly to the TBCSA protocols or our own internal protocols, but those we have to follow. So both sides of the contract have taken on more liability and more risk, but also more responsibilities. So it's not, again, it won't preclude anyone from litigating. It won't preclude anyone from making demands, but it will at least put you in a position to by way of correspondence, which is what we would actually want. It is to sort it out by way of a few letters, a few phone calls, maybe some negotiation. But if you don't have those things in place, then litigation is the only way, because no one would drop a fight if they know, but you've got nothing to lean back on. So no, it's no blanket cover. It's not, unfortunately, the Hail Mary, but it's flipping close if you do it right.
Please keep your questions coming in. Even if we're not able to respond to them verbally, we will do our level best to make sure that you get responses in text after the fact. So please do keep those questions coming. It's a related question, Stefan, but I'm going to pitch it because we've got it a lot, and it is very specifically around refunds from a kind of lodge and hotel perspective in a situation where, for example, a guest has had to cancel and they're now not paying over the deposit, for example, or the full amount that was settled. My understanding, having gone through this discussion with you on a regular basis when it comes to the T's and C's, is that there isn't a blanket T and C. It literally is whatever is in the T and C's of the specific lodge operator or the hotel is what stands. So for you to provide any guidance on that would be very difficult. Am I wrong, or do you have anything to add to that?
Yeah, it is unfortunately difficult. It comes down to the terms of the contract between the operator and its suppliers and its clients. But what one must keep in mind, as I said earlier, it is a contract. Any services you render is subject to the terms of a contract, whether it be in writing or a verbal agreement. So you are bound to deliver certain services in exchange for payment. If you are no longer able to deliver that services for whichever reason, I mean, it's their fault, your fault, no one's fault, then certain consequences will follow. If someone pays you an amount of money to undergo or to partake in a specific tour and that tour is curtailed, then technically the go-to would be that they are entitled to some form of a refund because they paid for a specific service and they did not receive that service. That's why it comes down to, what does my terms and conditions say? What does my contract say? You can fall back on your contract and say, listen, we've done everything we could. You run this risk. We won't be able to refund you in full. We are obviously reliant on our suppliers to come to the party and to tell us, okay, we'll be willing to refund or not. So paperwork, very, very important from the get-go, but unfortunately, no blanket answer there.
Okay, Lucian, I think this one is for you, and it's around the bad behavior of travelers. So that's great. We've now, as Ona said, signed our life away and said we are going to be complying with these fantastic travel safe, eat safe protocols and the health and hygiene requirements in the occupational health law. But now we cannot get our guests to wear their mask. How do you deal with that? I mean, surely one would argue that the lodge is not at fault and it's actually the behavior of the guest. How do you deal with that practically?
Okay, so it is a difficult one because at the end of the day, tourism is about hospitality and it's about being nice to the people. From a medical perspective, I myself obviously am not always like that. I need to do what's best for the world and my clinical practice. So the point is, I've had a situation actually where I was at a 5-star lodge, full-blown crazy level of amount of money that they charge, and the guest walked in wanting to get a medical consultation. There was an emergency situation, so as a paramedic, I was asked to go and assist. And as he walked in, he wasn't wearing his mask, and I stopped him and I said, "Sorry, excuse me, I'm not going to assist you until you put your mask on. Otherwise, I need to leave." And for two reasons. Number one, I obviously have to protect myself as a healthcare worker, but also the fact that honestly, it's the law. It's when you wouldn't dare walk into a Pick and Pay or to a spa or anything without your mask on. There's not a chance you would do that because the fact is you'll be fined. You could, possibly be arrested. Who knows what the people decide to do? At the end of the day, it's the same thing. Like an operator is not going to turn around and take on people onto a vehicle without a first aid kit, or at the lodge, they're not going to not have a first aid kit, or they, not going to have a chef who can't cook dinner. And there are just certain basic requirements that you have to have. And one of the requirements at the moment is that you've got to follow the regulations. If a guest turns around and is walking around a lodge, they're supposed to wear a mask. If they get onto a game drive vehicle, they are supposed to wear a mask. The only time they're not supposed to wear a mask is when they're in their room. So at the end of the day, there's nothing wrong with making it. First of all, they talk about the fact that one must put signage around the property to remind people. One of the things I recommended to the lodges is at the back of the room, for example, the door where they open the door to leave the room, to put a sign on the door saying, "Please remember to put on your mask," because the point is everybody has to do this. I mean, when you board a plane, an aircraft, I was on a flight not so long ago, and on the flight it was an international flight, and they actually said to me when I was on the flight, they woke me up because my mask had come off while I was sleeping. It had actually shifted off my face, and they actually woke me up and said, "Excuse me, please put your mask back on." You literally have to wear your mask the entire flight. You've got no choice in the matter. But somehow in the South African tourism industry, and I think this is why people love coming to South Africa for holiday, we've become so we want to attend to their every need and to become so, back down from them and give them everything they want. But at the end of the day, you're not going to let a guest drive your game drive vehicle, and you're not going to let a guest into your kitchen to cook. So I know these are absurd examples, but the point is not wearing a mask, in my perspective, is absurd. And to even remotely recommend it to, and I know that they do. I have been to a lodge in December where I arrived and they told me wearing your mask is optional. If you would like to do so, then do so. If you don't want to, you don't need to, but we will always wear our masks as the staff. And I said to them, but the regulations are clear. You need to wear your mask. And the fact that they verbalize it is strange for me. I think there's a big difference between offering hospitality and being reckless, and actually stating to your guests that they don't need to wear a mask if they don't want to is reckless. It's almost like telling somebody to sniff cocaine if they'd like. At the end of the day, it's against the law. You have to wear your mask in a public place. That is the way it is. And I know I'm very unpopular in the tourism industry now for saying that, but that is the truth.
Okay,
at the end of the day.
we still love you. It's all right. All right. Anna, did you want to
quickly butt in and just add something there? I think, Lucian, from what I've heard, people who do follow, who do make it optional, the way they see it is that their property is private and the regulations require a mask wearing in public. And they fail to make the distinction that if you have other guests, all unrelated guests on the same private property, then essentially that is also public space. And I don't know if Stefan can comment on that, whether it's public or private, but that to me is the reason why they feel they can get away with it. And it's like you say, we are in the hospitality business. We want to be nice to people. If people don't want to wear their mask, we want to make it optional. I fully agree with what you're saying, but I know that many lodges have made it optional, and I don't see it when I look around me on game drive vehicles. I do not see people wearing masks as a rule. So yeah.
Okay. Great questions, guys, that you guys are putting through. Please keep those questions coming. We'll try and deal with them. I'm going to do 2 more questions, but don't worry, we will get to your questions. We'll just answer them in text. And that is one that I actually had a conversation about with SATIB yesterday, because they raised that customers were asking around the legal requirement of professional driver permits, driver's licenses, etc., that have expired and need to be renewed. But the local licensing office in the blah has been closed, and from the government website it says that there is a dispensation until August 2021. Are operators in the clear in terms of their insurance contracts as government has granted extensions? So I don't know, Stefan, if you would be able to weigh in on that, but I know that it was a particular pain point for some of SATIB's customers. Do you have any insights?
Yeah, that question was posed to me as well. So yeah, I answered it. Yeah, the short answer is, as far as I understand the regulations that was published by the Minister of Transport, it is only in as far as a license expired up until the 31st of December 2020. Those received extensions until the end of August this year. If, however, and again, that is my view, because there's no mention made of any licenses expiring after this 31st of December 2020, you won't receive the same leeway as you would had it expired earlier, which doesn't make practical sense, but that is as far as the regulations stand. My advice in that instance is to document the steps that you have taken in order to comply, in order to renew. Draft your affidavit, advise that I wanted to go to the specific traffic department to have I think it was a PDP that they wanted to renew. They advised us that they've got a COVID case there and they are closed. They can't assist us in any way. It's highly unlikely for an insurer under these circumstances to refuse or repudiate a claim because your PDP expired. If you can show them, but listen, I went there to renew, but the offices were closed. They said they'll only assist us on this date and that time. I went back again, same issue. But what you must also keep in mind, on the Department of Tourism, the Department of Transport's website, they also advise people to see to it that you renew your licenses at least 4 weeks before they expire. So because you've got that information, and it is advisable to do so in any event, you are now taking on an additional responsibility. You know when your license is set to expire, you know that you can renew it a little earlier or before it expires. The last year has been a difficult one, but that's why we've got specific relief until the end of August. But from now onwards, you don't have that same protection. So make sure that you do everything you can to comply. And when it's practically not possible to comply, document it so that you can state your case when and where necessary.
Great, thanks, Stefan. I'm actually going to be sneaky and sneak 2 questions in. First question is is to get a definitive answer about what is public and what is private space, because I know that I've had a million questions asked whether it's a public pool or a private pool when it's in a hotel. And owners just raised how, they say that it's a private place, that it's not a public place. Lucy and I kind of have a sense of where you're at. As far as you are concerned, it is public. Am I right?
Well, at the end of the day, the point is it's a workplace and there is an Occupational Health and Safety Act that's in place. So it doesn't matter if it's private property, it's a commercial space that has to obey by certain regulations. That's my stance.
Oh dear, that means anybody who's been emailing me about their pools has just received the wrong information. Anyway, and the last question is for Stefan, and that is around, quite a few people have asked it around, what are the kind of key critical elements that one would need to include in terms of contractual liability that would help deal with that negligence argument? So what are the kind of things that you need to pinpoint and make sure that you've got in a contract to make sure that you are covered as much as possible?
Sure. Difficult. because
Give me
again,
5.
no blanket. That costs a lot of money. Those 5. No, a blanket. No blanket answer. But we have discussed on a previous webinar contractual terms. And as we said earlier, we are in the hospitality, in South Africa especially. We want to please everyone. I know they say the Canadians are quite fun people, but I think the South Africans are the nicest when it comes to international tourists. We literally bend over backwards more than is legally possible in most cases. But remember that the contract terms, very, very important, especially with the international travel agencies, because I've read contracts and contract terms that are insane. The type of risks that they transfer to you, the type of indemnity you give them is absolutely ludicrous. And everyone simply signs it because we want the business, we want the business. Remember, no business better than bad business. So you must make sure that in your contracts and your dealings with the international community, that you protect yourself and you protect our local industry. Just because the oak down the road is happy to sign that agreement, is not reason enough for you to either sign the same contract or to take on the same risks. It doesn't make sense. If the oak next door doesn't enforce regulations, it's his risk. It's his problem. If you lose out business because you enforce the regulations and you enforce the law, well, sure. How could that be a bad thing? So what do you need to include into your contract is you need to advise your clients what it is you are going to do for them. What are the services that you are going to render? They have to understand what type of risks they'll be exposed to. You have to understand what type of risks they'll be exposed to. So you give them a list of activities. Apart from the itinerary, I mean, you can include additional activities because we don't know what happens. Once they board the tour, we may decide to go for a hike randomly because we've got half an hour or an hour and a half available. So make sure that you can identify as many specific instances where they may incur some form of risk, and then be specific and be clear. Just put all your cards on the table. Advise them. This is a contract. I run a business. You are going to spend money on me. I'll give you my absolute best, but that doesn't mean that there's no risk for you. It means that we'll do whatever we can, but both of us are in this together. So if you can get that message across in your agreements, then the possibility and the likelihood of litigation is just mitigated exponentially.
There you have it, folks. We are in this together. I want you to keep that in mind because I think we are going to need to be in this together more so than we were in it in 2020, to be very honest. I want to thank all of you who've posed your questions and attended today. Zephanie, Leslie, Glenn, Christopher, thank you so much for sending your questions and we will deal with them, I absolutely promise. Lucian and Stefan, always a pleasure. Thank you so much for joining us today and unpacking that stuff for us. And Anna, for saying we have a problem. We need to help. Thank you for raising it. So if you want to be like Anna and let us know if there are any things that are particular pain points that you need help with unpacking, we want to hear them. Please let us know. You all know where to find me. Have a wonderful week. Be safe. And thank you for your attention. We really appreciate you. Thanks, guys. Until next time. Cheers.